I have recently purchased a sectional title unit from a well-known property developer. They had indicated to me that the registration would occur by a certain date. However, it appears as though registration has now not occurred or been delayed, rather. I suspect that the delay is due to the developer's action or inaction or lack of action. Is it possible to contest occupational rental in an instance where registration delays are caused by the developer? Bruno?
So registration hasn't taken place, so the viewer isn't owner of the property. So that's something that we need to be mindful of at this moment in time. I know that this wasn't an exact, this wasn't part of the question, but for the sake of everyone else, if the registration date has passed, or rather the promised registration date has passed and still hasn't taken place, that is a breach of the agreement. So obviously it depends on the circumstances, why there was a delay, whose fault it was. There's a whole bunch of reasons why it wouldn't be a breach. But normally, if we go with what the viewer is saying, and it was the developer's fault, this could very well be a breach of the agreement and could open up the question of canceling the agreement and actually walking away from the transaction altogether. The reason why that's also relevant to mention is, and Cilna, and I know for a fact Cilna will agree with me on this, so as lawyers, we don't just look at the exact facts, the problem, and just the outcome. Because sometimes to get a certain outcome, you need to understand what other outcomes exist, because those will, those might be used to negotiate. So would a developer want you to step out to cancel the contract? No, they wouldn't. So if you go in there and say, look, I don't want to pay occupational rent, so I will cancel the contract unless you agree that I don't have to pay occupational rent anymore. So things like that in the law game typically tend to help. So that's just something to bear in mind. If we're looking strictly speaking at the occupational rent, yes, there is room to argue that due to a delay in the registration of the property, that a person shouldn't be paying occupational rent. On the flip side of things, and this is where the complication starts arising, you are still enjoying occupation of the property. So it really becomes a question on, it's almost enrichment. Yes, the reality is you should be owner by now, but as owner, you would have enjoyed occupation anyway by virtue of your ownership. Now you're enjoying occupation, so almost as a tenant. So how can you refuse to pay rent where you are technically tenanting the property, and ultimately, even had you bought it, you'd probably have to be paying some sort of bond payment. You need to cover the property rates, whatever the developer is paying now, you would have to be paying anyway. And so that's why I wanted to mention that if a person uses the fact that you may be entitled to cancel the agreement as leverage to then negotiate with the developer to say the rent needs to go down, needs to cover bare minimum. I understand I'm still in occupation, so there are certain holding costs that you might be experiencing that we just kind of need to negate. But ultimately, you would probably have to pay something or other. But you could use the threat of cancellation to get it to a figure that's more suitable to you, or get them to rush.
Thanks, Bruno.